Should I mediate or go ahead and file my divorce? Hi, I'm Bill Farias, founder of Farias Family Law. I spoke to a gentleman last week who asked this exact question. Mediation is very popular. Mediation is very helpful in some cases, but it's a tool that has to be used at the right time. And this video is going to explain what you should think about when determining whether you should start with mediation or get your case filed, get it into the court system, and then maybe at some point explore mediation. So this really depends on your specific circumstances. This is a strategy decision, and there are a couple of main factors that you should consider. Number one, you have to consider what's going on with the finances. And what I mean by that is there are certain circumstances under which you have plenty of time, and taking that time is not going to compromise you, and therefore you have the luxury of exploring mediation if it's the right fit for you and your circumstances, and not having to worry about getting the case into the system and moving it along. A couple of circumstances under which it does not make sense to mediate first, and you may want to consider filing to get the case into the system, is number one, if you're in a bad financial situation and you need support. So the problem here is that if the other party is not paying you a fair amount of support, the other party has incentive to drag out the process. So if you are mediating and you don't have a case in the system, there is no mechanism for forcing that party to pay a fair amount of support. Number two, if you are confident that you need to get your house sold and you feel like the other party is not going to cooperate and they are going to stall, then it is also risky to start mediation before actually filing the case. And the reason for that is similar to situation number one, there is no mechanism for moving along the process and eventually getting the house sold. Now, if you file, that doesn't mean that the court is going to order the house be sold immediately. In fact, in most cases, that's not what happens. It takes some time, but filing the case at least gets it into the system and moves the case along. And ultimately, the person has an ultimatum. And by the person, I mean the other party who is wanting to stay in the home. They either have to execute a buyout or sell the home. And the default decision for a court, usually, if the parties cannot work something out, is to order that the home be sold. So the point here is that the longer it takes you to actually get the case in the system, then the longer overall you're going to have to wait to get that house sold. And I said there were a couple of reasons. There is actually a third reason, and that's the automatic restraining order that goes into effect once a divorce is filed. So when a divorce is filed, there is an automatic order issued by the court to both parties that prohibits transactions that are outside the scope of regular expenses. And so where this comes into play is if you think the other side is engaging in funny business, if you don't know what's going on with the money, if you suspect that the other side is going to try to do something with the money to put themselves in a better position and to compromise you, you may be better off getting the case filed, because once they're served with this automatic restraining order that restricts the transactions that they are allowed to make. And so that is another consideration in determining whether you should move toward mediation and there isn't really any mechanism for enforcing anything and no real rules, or you should just get the case filed, get it into the system, and get yourself that protection and move the case along. So When it comes to the finances, those are just some considerations. Those aren't all of them. Those are the main ones that come to mind in determining whether you should mediate right off the bat or file the case. Another one is the children. You have to think about what's going on with the children. And the main issue here is that, similar to the issues with the finances, the mediator doesn't have any authority to order you or the other side to do anything. And so if you are in an arrangement that may not work out and you might need a court to weigh in on that and make a decision on the arrangement for the children, then it's in your best interest to get the case filed and move it along, right? You want to have this, in some cases, you want to have this option to file paperwork with the court to get in front of a judge. That's called a motion. If you are mediating and you don't have a case filed, then you can't really do that. You got to get in the back of the line and wait behind everyone else. So if you're in a comfortable arrangement for the children and there's a strong probability that it's going to continue that way and you're not going to have issues, you have the luxury of considering mediation before getting anything filed. If you think there might be an issue on parenting time, custody, then you should get the case filed and get it moving and get it into the court system so that you have that option of going in front of a judge in case you need it. So those are the main considerations for whether you should mediate off the bat or get the case filed. If you have any questions about this, you can call us 508-675-0464. You can email us at info@farriersfamilylaw.com. If you found this video helpful, please like it, subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farriers Family Law. Thank you. Have a good day.